Okay, this is National Popular Assembly meeting 4/8/2020, and tonight we're going to be finishing off reading from History of Law of U.S., which we've been talking about the last couple nights. That was written by a gentleman called John B. Nelson back in 1992, and it gives a very good long description of a vast majority of the things that happened during the New Deal after Roosevelt's New Deal in '33, where they basically took our estates and then started administering them to turn around and give us a benefit of our own estates instead of having us control our property and our lands and our bodies by allodial title. So I'm starting about 2/3 of the way in. It appears from the documentary evidence in the Internal Revenue Service agents, etc., that the Internal Revenue Service agents, etc., are, quote, agents of a foreign principal. Okay, now you got to remember that the Internal Revenue Service is based out of Puerto Rico. Okay, that's where it has its home at. And I don't want to get into the extreme details of what Puerto Rico is and what it deals with, but let's just leave it at the fact that Puerto Rico has always been a haven, a tax haven for basically pirates and all the other people of England that wanted to basically hide their wealth there. So now they're literally hiding their wrongdoings there in the form of what's called the Internal Revenue Service. So within the meaning of the intent of the Foreign Agent Registration Act of 1938, they are directed and controlled by the corporate governor of the, quote, the fund, aka Secretary of the Treasury. See public law. Well, I'm not going to read all the public law, but you guys can read that at your leisure if you want to and look it up. Okay, and the corporate governor of the bank acting as information services employees. So this is where you have the connection of the Secretary of the Treasury, the Internal Revenue Service, and ultimately the IMF, which is the other connection to all of this from the aspect of what they get from the special drawing rights. The United States Incorporated can take special drawing rights off the IMF, just like every other corporate government that has a central bank. What are the special drawing rights? What are they drawing off of? They're drawing off the aspects of our estate. Okay, so to continue. And the corporate governor of the bank acting as information services employees. Okay. And have been and do now solicit, collect, disperse, or dispense contribution, tax pecuniary contributions, Black's Law Dictionary, 5th edition, loans, money, or other things of value for or in interest of such foreign principal, and they entered into agreements with foreign principal pursuant to Treasury Delegation Order number 91, i.e. the Agency for International Development. Okay, so when you see these agencies for international anything, you should pay close attention as to the connections of where they came from and what they're actually doing, because this is where you get into the aspects of the New World Order, of the United Nations, of Agenda 21, of in the United States, particularly the Uniform Commission of State Laws, which is where they're trying to uniform all of the states into uniformity so that they can then bring in totalitarianism from the top in a uniform way, so they don't have to, so that all these stupid attorneys out here don't have to relearn anything. So to continue, the Internal Revenue Service is also an agency of the International Criminal Police Organization and solicits and collects information for 150 foreign powers. See 22 U.S.C. 263A. The United States Government Manual, 1990 and 91, page 385, and also the Ron Paul Money Book. It should be further noted that Congress has apportioned, transferred, and converted vast sums to foreign powers, and has entered into numerous foreign taxing treaties, conventions, again, pay attention to the conventions, and other agreements which are solicited and collected pursuant to 61 IRC, so on and so forth, along with all other documenting evidence submitted herewith. This should absolve any further doubt as to the true character of the party. Such restrictions as, quote, for the general welfare and common defense of the United States, close quote, apparently aren't applicable, and fraudulent rehypothecated debt credit will be merely added to the insolvent nature of the continual, quote, emergency. Now, of course, that's saying a lot in a sentence. Fraudulently rehypothecated debt credit. That's probably the single best sentence I've ever heard as far as to describe what the fiat currency system is. They take our credit, but of course it's also a debt. So there's the debt credit thing, because this is a dual bookkeeping entry system that again was started by the Venetian black nobility way back, and they were the first ones to develop it. And what it is every time there's a credit, there's a debt. Okay, great. Well, our credit, the credit of our estates, is being rehypothecated into various different things of securities, everything from mortgage-backed securities to all of these ridiculous amount of derivatives that are out here, which are all going to blow up very soon, and are already starting to. And it will be merely added to the insolvent nature of the continual emergency. Well, whose emergency? Who caused it? They did. They caused the emergency. Okay, so this is classical Hegelian dialectic. Problem that they'll create, reaction, which they know will come, and then solution, which they'll provide, which will put you right back into the circle again. So that's the Hegelian dialectic. So you keep problem, reaction, solution, and keep them choosing between two different decisions that both lead to the same slaughterhouse, basically, is how you keep the sheep going in the same direction. Okay, so to continue. And the reciprocal socio-economic repercussions laid upon present and future generations, which is, of course, what all of the central bank is, including the Internal Revenue Service. Among other reasons for lack of authority to act, such as Foreign Agent Registration Statement 22, USA 1612, so on and so forth. Military authority cannot be imposed into civil affairs. See Department of the Army pamphlet, so on and so forth. The United Nations Charter, Article 2, Section 7, further prohibits the UN from intervening in matters which are essentially within the domestic jurisdiction of any state. Korea, Vietnam, Ethiopia, Kuwait, etc., are evidence enough of the bad faith of the United Nations and its organizations. Well, that's, yeah, to say the least. Not to mention the seizing of 2 daycare centers in the state of Minnesota by their agents and holding the children as collateral hostages for payment ransom of their fraudulent, dishonored, rehypothecated debt credit, worthless securities. Such is the, quote, rule of law, close quote, as envisioned by the founders of the United Nations, such as communist terrorism, despotism, and tyranny. All were and are outlawed here. Again, that's quite a bit to say. Interesting note in the beginning of that paragraph, the aspect that military authority cannot be imposed into civil affairs. Well, yeah, fine, but at the same time, you got to remember that the Lieber Code's still in full force and effect, and so are all of the Reconstruction Acts since the Civil War. So technically, we've been under martial law since then. They just don't like to admit it. And there's been talk about going to provost marshals after we claim estates and so on and so forth through the status docs and say, look here, all my stuff back. I don't care what they're doing, but you're the one that's in charge of protecting the republic and the property they're in. So either I want direct connection with you saying, yes, you are protecting me because I'm one of the people of whatever state you're domiciled in, and or just give status or give it back to me, one way or the other, or go get it for me and give it back to me from them. There's another way to put it. So to continue, I hope this communication finds you well and mentally strong for the occasion. It is quite apparent that the treasonous and seditious are brewing up a storm of untold magnitude. It's funny that he mentions a storm. This is obviously a way back, so this was when Bush was president. Bush's public address of September 11th, 1991, weekly contemplation of presidential documents, should further qualify what is being said here. He admitted interdependence, right, of one world order, affiliation and collusion with the Soviet Union oligarchy, direction by the UN, so on and so forth. You might also find interesting that the Treasury Delegation Order Number 92 enclosed states that the IRS is trained under the direction of the Division of Human Resources, UN, United Nations, and the Commissioner International by the Office of Personnel Management, so on and so forth, United Nations. You will find Executive Order Number 10422, the Office of Personnel Management, is under the direction of the Secretary General of the United Nations. That alone is creepy enough. And as stated previously, the IRS is also a member in a 150-nation pact called International Criminal Police Organization, found in 22 U.S.C. 263A. That's U.S. code, by the way. The memorandum and agreement between the Secretary of Treasury, corporate governor of the fund and the bank, and the office of the U.S. Attorney General would indicate that the Attorney General and his associates are soliciting and collecting information for foreign principals, which is obviously true. As far as you can consider it, D.C. itself, the District of Columbia, is foreign to us, always has been, after they set it up, after the D.C. Municipal Act, which was set up in, I forget the exact date, 1870 something, after the Civil War, which set up its own government and is what we now know as the United States, being a federal corporation, which is 28 U.S.C. 3002, I believe, 3002 15A, I believe. It is noteworthy that an attorney representative is required to file a foreign agent's registration statement pursuant to 22 U.S.C. 611 C1 and 612 if representing the interest of a foreign principal or power. See, okay, so people keep saying to me, well, don't the attorneys have to register under the Foreign Registration Act, FARA? I'm like, well, only if they're representing a foreign principal or power. Well, how can you lock them to that? You got to basically get your status docs done and say, look, I am one of the people of Illinois, or I am one of the people of Wisconsin, or whatnot, and say I'm also an American citizen, and everything else that it states in the status docs, everything from what's in the KW all the way through the Declaration of Nationality. And because they cannot deny a Declaration of Nationality, or nor can they deny a Declaration of Expatriation under the Expatriation Act, you're basically saying, look, I am foreign to you. I am one of the people of my particular state, and you are DC. You are the District of Columbia. So you're foreign to me because you're bringing these foreign statutes, acts, ordinances, and codes upon me as an attorney. You're representing a foreign principal or power. Now, I don't know anybody that's actually done that as of yet. But actually, there appears to be looks like there's a case here. Rabowitz versus Kennedy. Okay, I'll post this in text because this could be an interesting case for looking that up. So we can take a look at that at our leisure for homework assignment. On January 17th, 1980, the President of Senate confirmed another constitution, namely the Constitution for the United Nations Industrial Development Organization, found at Senate Treaty Document number, so on and so forth. A perusal of this foreign constitution should more than qualify the internationalists' intents. The preamble, Article 1, objectives, and Article 2, functions, clearly evidences their intent to direct, control, finance, and subsidize all natural and human resources. Yeah, human resources. That's what you are. You're nothing but a resource, like tin and iron and rubber, traded on the stock market and with a fidelity bond stamped to your ass. And agro-related as well as basic industries through dynamic social and economic changes with a view to assisting in the establishment of a new international economic order. Well, New World Order, right? The high-flown rhetoric is obviously for communist origin and intents, clearly. An unelected, unrepresentative, unaccountable oligarchy of expatriates and aliens who fraudulently claim in the preamble that they intend to establish, quote, rational and equitable international economic relations. That means I own you. Okay. Yet openly declared that they no longer, quote, stabilize the value of the dollar, close quote. Well, their intention was never to stabilize anything as soon as they came in with the Federal Reserve, or any other bank of the United States, or any central bank, ever, period. That's not the point. The point is to destroy the currency, have hyperinflation, and run off the back door with all of the actual tangible assets, the things that we, unknowingly and ignorantly, pledge to them, whether it be our land, our property, our cars, or our very children. Okay. Nor assure the value of the coin and currency of the United States. Clearly, they've stolen the gold a long time ago. Is purely misrepresentation, deceit, and fraud. This was argumented by public law, so on and so forth, which discloses massive appropriations of rehypothecated debt credit from the general welfare and common defense of other foreign powers. Right. Why are we giving so much money to all of these other nations all around the country or all around the world that clearly want us destroyed? I could name a whole bunch, but I'll just say Israel for one. Including communist countries of satellites, international control, and natural human resources, etc., etc. A, quote, resource is a claim of, quote, property, and when related to people constitutes, quote, slavery, clearly. That's the reason why you have to claim your own estate. Okay, what they were doing, and this is just going to be kind of a really a rehash of what we were talking about the last couple of days, about what they used to do in England. What they had in England was what was called the Court of Wards and Liveries, and it ran from about 1540 to about 1664, I believe. And then afterwards, they said that they got rid of the Court of Wards and Liveries, but instead what they did is they just morphed it into what was called the Court of Wards, which they then gave total, absolute 100% permission to run to the East India Trading Company. So, there you have a corporation who is now administering and deciding the property of wards who come to it to say, hey, I'd like to sue out my livery. I've come of full age. I want my stuff. Well, think about it. What do we have here? We have a corporation which has totally and completely occulted even the capacity to come forward and claim and say, hey, I want my stuff. Meaning, I've come of full age, I've been found to be living. Well, and then, of course, right after they got rid of the Court of Wards and Liveries, around 1664, they burned London to the ground, killed 70,000 people, and then came in with the Sester K. Vi Act, which said, unless you're found to be living in an action for return of your profits and estates, guess what? You're lost beyond the seas, and we don't know where you are, and we're going to administer everything. Which is exactly the same modus operandi that these filthy scumbags have had for thousands of years. You take it back to Rome, when Nero burned Rome at the agreement, and dare I say behest of the Senate. And then they instituted the 12 tables, which if you go look at, again, is this aspect of, hey, unless you can prove that you own this thing, guess who gets it? Caesar. So, this is modus operandi for them, always has been, and you can see it through everything that's in the IRS regarding the fact that all 1040 forms and all W-9 forms are all Class 5. Class 5 is gift and estate tax. It's not income tax. Estate. You're being taxed for the use of your own estate because you haven't claimed it. Okay, and the other thing that you're labeled in is in your master file in the IRS is you're labeled as a decedent. Okay, so they don't know where you are. You're dead, which is the reason why all of the birth certificates have all capital letters names on them. That's the name of the estate. The all capital letters name with the middle initial period in it is the constructive trust that they create and set up for Social Security, which is usually also the name that they have in any sort of what they call to be a criminal trial. It's not criminal at all, because all crimes are commercial, which is under U.S. code. And forgive me because I forget that particular U.S. code off the top of my head, but I will put it into. I'll put it into class 2, to end the class. And so all of this is a perpetuation when you look at it from what they're doing in America, in a much more spread out, vastly more spread out, deviant way to control and administer all of these various different parts of what should simply be a man's estate or a woman's estate. And the substantive definition of an estate is everything that a man or woman owns in law. Okay, so that's all your rights of everything you have from your property, because rights are derived from property. And if all of your property has been pledged to a king or a corporation, or is sitting in trust in a trust company, and they're acting as a guardian, which is what you can find in the Washington D.C. Code, is that the trust companies are acting as the guardians, and that the Bar Association is hired by the trust companies to be the administrators, which is why you have a black-robe priest of El sitting as an attorney up on a bench administering justice to you. Well, he's not giving you justice. What he's administering is deciding what is going to happen with the abandoned res estate property. And so in all of this, in everything that they're doing, they have perpetuated and perfected the system from Rome to England, and then they had to break us in half during the Civil War, and then they perfected it here through contractual obligations and force, fraud, lies, and coercion, basically, to confuse the populace of the several republics here to enter into contract, and so thereby give consent to quote-unquote be governed, but not by the original republics of which we established as the people, but as de facto corporations acting as de jure governments. Which, of course, you can all find in, if you want to look any of them up as to what they are. Of course, all the local ones are very easy to find. You can find most of all of them on Dun and Bradstreet, dmb.com. Just go look up the name of your local district attorney, and it'll say also traded as so-and-so county, because they're all for-profit business of which they're taking. And here's the other thing. Anybody ever want to wonder why attorneys always take 30% of everything you do? It's basically the administrative fee of administering your estate until you come forward to claim it. And that, not the 30% part, but the part that the administrators do have a right to collect fees, goes all the way back to the Magna Carta, all the way back to 1215. It does state in the Magna Carta that it's lawful then to collect a fee. However, the fact that there should never have been any administration to begin with, of course, nullifies that argument. So, okay, so that's my little catch-up part. So, okay, to continue. It is now necessary to ask which constitution they are operating under. The Constitution for the new states of the United States, which was located at Liberty Lobby, 300 Independence Avenue, Southeast Washington, blah, 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 was the subject matter of a book entitled The Emerging Constitution by Rexford G. Tugwell, which was accomplished under the auspices of the Rockefeller Tax Exempt Foundation, called the Center for the Study of Democratic Institutes. Yeah. You ever want to know who's actually running and pushing all these agendas? It's tax exempt foundations. Mainly Rockefeller and Carnegie. Okay, the Rockefeller and the Carnegie foundations are instrumental, have been instrumental, and are continuing to be instrumental in the destruction of our education system and the destruction of our republic in total. And there were two major hearings that happened regarding tax-exempt foundations that looked into Rockefeller and the Carnegie and a lot of other foundations as well. One was called, it's called the Reese Committee. That was done by Congress, and then there was another one that was headed up by a gentleman his name was Norman Dodd, and you can still find, because I think I just went looking for it the other day, and I think you can still find it. There's a really, really good interview on YouTube that G. Edward Griffin does with. He interviews Norman Dodd like just a few. Actually, I think it was a few months before he passed away, and the information in that interview is stunning as to what Norman Dodd found, and if you get into the understanding of what the Reese Committee is and what they figured out as far as what these tax-exempt foundations have been doing for, decades, you really start to see the much bigger picture as to who's at fault here, if you will, or to point at who's in control of the New World Order. So to continue, the people and citizens of this nation were forewarned against formations of quote democracies. Democracies have never been the spectacles have ever been the spectacles of turbulence and contention, have never been found incompatible with personal security or the rights of property, and have in general been as sort in the lives as they have been violent in their deaths. Clearly, the founding fathers didn't set up a democracy. They didn't want anything to do with democracy. They knew exactly what it would be, what it turns into, which is eventually despotism. This is a constitutional republic. Anybody that says otherwise, one, doesn't know their civics, or clearly is a foreign agent trying to persuade you otherwise. So this alien constitution, however, has nothing to do with democracy. In reality, is it a basis for a despotic, tyrannical oligarchy, which is, of course, what we're seeing. Thank you, Jarrett. Yeah, all crimes and commercial, 27 CFR 7211. And that, in connection back to this again, is what they're doing, because they're running everything through the law merchant. Okay, there's 5 jurisdictions of law in American jurisprudence. Common law is the highest form of law, and technically, if you want to consider this, natural law is part and parcel of common law, and technically part of it and kind of above it at the same time. So you have common law, equity, which you can also consider and wrap into that also the aspect of chancery. So chancery, you should think of chancery and equity kind of the same way, but technically equity is a way of dealing with matters of court and certain things, and chancery is actually a court, a specific kind of court of which you go into. Then you have maritime admiralty, which deals with banking and merchant affairs. Then you have military, which deals with court martials. And then you have ecclesiastical, which technically it still deals with matters of probate, but the attorneys are never going to admit to that, even though you can read treatises on law, even back to very early 1900s, that still talk about ecclesiastical jurisdiction. So anyway, those are the 5 jurisdictions of law. So the connection in what they're doing is they basically merged common law and equity into one. But here's the thing: they can never truly merge these things. It's just basically what they did is they took water, oil, and sand, put it in a jar, and shook the hell out of it, and they just keep shaking it. Okay, but if you let the bottle go, they'd all separate back to where they should be. Okay, so which is what you finally get in the aspect of what in when you look up the Federal Rules of Civil Procedure, the first thing that you'll find when you read the Federal Rules of Civil Procedure, it says there is one form of action, and it is the civil action. Well, civil law, Roman civil law, is foreign to us. Always has been. If you read the Declaration of Independence, when they're talking about, and he has subjected us to law that is foreign to us, or foreign law, that's what they're referring to. Okay, that's the foreign law, the Roman civil law, the things that has nothing to do with us, unless of course you contractually put yourself into it. And that, from that understanding and that connection, you see the understanding of the law merchant, which is why I put the thesis paper for the law merchant in class 2 on Monday. So everybody should take a look at that and just read it for homework assignment if you want to. It gives you a really good understanding of how the law merchant weaved itself into English law, English common law. So all those connections from the standpoint that all crimes commercial, they're using the idea through trusts and usufruct, the idea that you don't own anything. You're only a usufructuary to be able to use it, but you don't own it. Because in Roman civil law, they split the title of everything in between equitable title and what they call legal title. And the person who holds the, quote, legal title is the one that actually owns the thing, and the one who holds equitable title is the one that has the right to use the thing. Now, At common law, you basically just merge the two of them together, and you have what's called a lodial title. A lodial title of something is absolute. There is nothing higher than a lodial title. Nothing. It's the right to use, the right to destroy, the right to sell, the right to all of it. And absolute cannot be taxed for its use, unlike under Roman civil law, where when you go and register something under Roman civil law, you go and ask Caesar, hey, protection. Give me protection, and please, Daddy, allow me to use this, which includes, and is not limited to, your own body, which is why they have the registration of the infants. So when all crimes are commercial, what it means is that they're fining and feeing you for the misuse, what they consider to be the misuse, of the property and estates of which you have not yet claimed. But if you claim them at law, there's nothing they can do to you as far as saying you're subject to this or you're subject to that. No, because all of those statutes, acts, ordinances, and codes are only the only things that are subject to them are infants, which is 1 United States Code, Title 1 United States Code, subsection 8 of the definition of person, which if you read it, it says that includes, definition of person, blah, 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 includes every infant member of the species Homo sapien. So what are the feds doing? They're just administering the estates of infants. But they're making all the crimes commercial because they can't be at law, right? So you can't say, oh, you're harming your own. Well, you can harm your own stuff at law. So if I decide to, destroy my body by being a heroin addict or something, it's my right to do that. I could totally decide to do that at law. No problem. No one can tell me not to do that. But if I'm damaging something that I have not yet claimed and somebody else, and I only have the right to use it, well, then guess what? I'm destroying its productive value. I'm destroying the aspect of the human resource. That's why all crimes are commercial. Okay, that's the connection. So back to the paper. So to continue. Article 1, Rights and Responsibilities, Section 115, evidence their knowledge of the emergency and the rights of expression, communication, movement, assembly, petition, and habeas corpus are all accepted from being exercised under and declared in a declared emergency. The Constitution of the new states of America openly declares, among other seditious things and delusions, that, quote, until each indicated change in the government shall have been completed, the provisions of the existing Constitution and the organs of the government shall be in fact, blah, blah, blah. So yeah, this whole thing is just one other, what he's talking about here, this Constitution for the new states of America is no different than the idea of the United Nations trying to come in over top of everybody and come from a top-down scenario and tell them what to do. It's exactly the same thing as the EU. Okay, the European Union coming in to sovereign nations and then ordering them what to do through Roman civil law. So I'm not going to read the rest of this part of this, goofiness about that. So I'll just skip down to the next paragraph. Apparently, the present operations of the de facto government under foreign alien constitutions, laws, rules, and regulations, the overthrow of the essential engine declared in and by the ordained and established Constitution for the United States of America, 1787, and by and under the Bill of Rights, 1791, is obvious. The covert procedure used to implement and enforce these foreign constitution, laws, procedures, rules, regulations, etc., has not, to my knowledge, been collected or assimilated, nor presented as evidence to establish sedition, conclusion, and conspiracy. This is what needs to be done by a grand jury. A grand jury could take all of this information, all of it, and could take down piecemeal, one at a time, or in whole groups if they wish to, large swaths of these foreign agents and indict them for, if nothing else, simple common law theft, which under the common law, first time offense for thievery is death. So just hang them all, right? A common law grand jury could do that, but you have to have 25 people, with also alternates would be a good idea. You have to have 25 people that have declared their status, have been found to be living, have come of full age, and have corrected the probate record. You have 25 of them, actual American citizens. They can do anything, basically anything. they damn well want to, for the exception of impeaching the president, because we gave that little tidbit of power to Congress to do. However, they can pretty much get rid of anybody else they want to, and they can indict anybody else they want to, and they can investigate anybody they want to. And every single corporation's documents, no matter what they are, no matter what corporation it is, can be subpoenaed by the grand jury. Failure to produce documents to the grand jury subpoenaed by a corporation, the holder or the custodian, if you will, of whatever documents the grand jury wants from the corporation, if failure to produce, the grand jury can hold that him or her in contempt of the grand jury and throw them into prison indefinitely. And no habeas corpus can get them out, ever, until they produce. That's Hale versus Hinkle. And that case has never been overturned, and that's an extremely important case to learn and understand the true power of the grand jury. You can't do anything when you're being held in contempt of the grand jury. It's the single most powerful force in American jurisprudence. And until we learn how to wield it again, we're going to be continued to be bombarded and attacked by these foreign idiots because we're not telling them no in the way that we should be. First, we have to tell them no on the private side and establish and make sure that we correct the probate record and the public record as to who we are in relationship to them anyway. But then, to truly gather power, we have to assemble 25-member grand juries to finish what we started, as it were. So, fortunately and unfortunately, in my land, it is necessary to seek, obtain, and present evidence to sustain a conviction or judgment. Our patience and tolerance for those who pervert the very necessity and basic foundations of society has been pushed to insufferable levels. They have fundamentally changed the form of substance of the de jure Republican form of government, exhibited a willful and wanton disregard for the right, safety, and property of others, evidence in despotic design to reduce my people to slavery, peonage, and involuntary servitude under a fraudulent, tyrannical, seditious foreign oligarchy with intent and purpose to institute, erect, and form a dictatorship over the citizens of our posterity. Pretty well written sentence. They have completely debauched the entire de jure monetary system, destroyed the livelihood and lives of thousands, aided and abetted our enemies, declared war upon us and our posterity, destroyed untold families, and made homeless over 750,000 children in the middle of winter, afflicted widows and orphans, turned sodomized loose among our young, implemented foreign wars, rules, regulations, procedures within the body of our country, incited insurrection, rebellion, sedition, and anarchy within the de jure society, illegally entered our land, taken false oaths, entered into seditious foreign constitutions, agreements, factions, confederations, and alliances under pretense of emergency, which they themselves created, promoted, and furthered, formed a multitude of offices, and retained those of alien allegiance to perpetuate their fraud and to eat out the substance of the good and productive people of our land, and have arbitrarily dismissed and held mock trials for those who trespassed upon our lives, liberties, properties, and families, and endangered our peace, safety, welfare, and dignity. The damage, injury, and cost might have been higher than mere money can repay, and they have done what they were commanded not to do. The time for just correction is now. So, indeed. Since consideration of presentment to a grand jury under the ordained and established Constitution of the United States of America, Amendment 5 is in order. I fully agree with that. Numerous high crimes and misdemeanors have been committed under the Constitution of the United States of America and laws made pursuant thereof, and under the Constitution for the state of Colorado and the laws made pursuant thereof, and against the peace and dignity of the people, including but not limited to, so on and so forth, which defines and prescribes punishments for seditious associations. That's a Colorado statute, by the way, 18-11-203. So, all of you in Colorado, if you want to take that one seriously and organize a grand jury, that can definitely be one that you can focus on. Now, I just want to make a note here. The three things that he's talking about from a standpoint of what we can do as a grand jury. Numerous high crimes and misdemeanors have been committed under the Constitution. Federal, yes. and also under the Constitution of the states. Yes. And the last one, in peace and in pursuance against the peace and dignity of the people. Okay, that little part right there, and against the peace and dignity of the people. If you go and look in any of the first constitutions of any of the states, I don't believe I've come across one yet that doesn't specifically state that process, meaning criminal process, will have a specific style to it. It'll say that process in this state, blah blah blah, so and so, shall be in the name of the people of Colorado and against the dignity of the same, or something to that extent. Each state has a different little clause that they have in their first constitution, and I always tell everybody to go look and find that clause. That's the clause that you should always write into any criminal action. So when you do and file, say, a trespass against these inferior courts, or against the all capital letter state of Colorado, or whatever corporate state is coming up against you, for exceeding their jurisdiction against you in a common law jurisdiction, you should look for that specific phrase that says, I so-and-so, one of the people of Colorado, bring this so-and-so action of trespass in the name of the people of Colorado and against the peace and dignity of the same. You can prosecute, any one of us, as the people, as the sovereign people, can prosecute a criminal act. It's just nobody's doing it correctly. And what does the state then have to do? It has to support you from the standpoint of the trustees that are hired to uphold our law in this form, in the form of grand jury, of what we decree to be the law and what we decree to say is criminal. And in a court of record, the sovereign decrees the law. They're the ones that decree and say, look, this is criminal and this is why. And then all you have to do is just prove it to 12 other members of the peerage, which are members of the sovereignty, not your equals, because it never meant equal. It meant a peer means a member, a fellow member of the peerage, a fellow member of the sovereignty, which, yes, is your equal, but you shouldn't confuse those two terms, or you shouldn't confuse the idea of that a jury of your peers meant equals. It meant fellow sovereignty, which, yes, if everybody's the same, yeah, okay, they are your equal. Okay. But the point is that when we start doing grand juries, I have it's about a 300-page grand jury manual at the moment. It was being edited by Michael Badnarik, who was a former Libertarian presidential candidate, but he had to take work out west and couldn't finish the editing. So I'm still searching for an editor to finish up the rest of the project, because there's parts and parcels of it that I still need to flesh out, like I want to put forms in there so that grand juries can be able to basically lay this book down in front of 25 people and pull out the forms, know what they need to do, file them, subpoena people, subpoena the corporate entities, gatekeepers, record keepers, if you will, and start digging into what all of these corporations do, start digging into what municipalities do, start digging into the reason why they're spending so much money to put fluoride into our drinking water. There's a good start. Why don't you look into the corporations that are pretending to be de jure law enforcement? Why does the sheriff's office need military equipment? Where'd you get the money from, right? And how'd all that happen? The grand jury can investigate anything they damn well want to. It doesn't matter what it is. Just on the simple suspicion that there may be something unlawful going on, the grand jury has the right to investigate. And there was a story one time out of Minneapolis, St. Paul, and grand jury was convened. The foreman was very highly intelligent and learned in law, and there was some corruption going on in Minneapolis, St. Paul, particularly between the mayor's office and the police department. And this particular foreman had pretty much had enough of that. And so he started to take things into his own manners, and the district attorney tried to get in his way, and he indicted the district attorney and said, "You can leave now." And what this particular grand jury did is that they pooled their money together, and they got they hired a private investigator, many private investigators, to start digging into and pulling information regarding the crimes of the various different people that were happening in the police department, and also that they were also in the mayor's office as well. And so what they finally did was this particular grand jury brought indictment, and then this particular grand jury foreman, because the district attorney wasn't going to prosecute his friends who were probably clearly paying him off, they prosecuted the case themselves. The foreman himself prosecuted the indictment and took out the mayor and the chief of police. So, is this the only time that this has ever happened? No. But I'm saying that this is what can be done. And so, when you fully understand the power of a grand jury, of what it can do, all the way through that extent, once we get 25 of us who are out in each state, and there was the suggestion made last time at one of my live face-to-face classes that we should get 25 out in each state, and all 25 members of the grand jury serve the Secretary of State and the governor as a grand jury with the status docs and say, look, we've claimed our estate. This is our status. You have to update all of your records as per this. And basically, if you touch one of us, you touch all of us. Where we go one, we go all would then literally mean something to the highest extent. I agree with that. It absolutely fully. However, everybody should do their status docs anyway to make sure that we can get to that 25 as fast as possible. Because the second that we get there, there is nothing that they will ever do to touch. If they even think about coming against a grand jury, that is literally 100% all-out war. And they're never going to be that stupid. Plus, there are too many learned men in law that understand that the grand jury is absolute power, not to mention the Supreme Court of the United States, and any Supreme Court members of any state court also are fully aware of the power of the grand jury, and that they're fully aware that we can convene a grand jury, even in secret, whenever we want to, without their consent. That's also in Hale versus Hinkle as well. It's clearly laid out. And it's also in the Williams case as well, which is, I believe it was U.S. versus Williams, or Williams. Yeah, I believe it was U.S. versus Williams. That was a case I think it was probably going on about a decade ago, where the Supreme Court specifically said that the people have the right to convene the grand jury whenever they feel like it, and there's nothing that we can do about it. We can't even give them instructions as to what to do, is basically what the Supreme Court said, because it would be exceeding our jurisdiction. So that's the end of the paper. That's my little rant about grand juries. Now, for an extra 15 minutes, because I think I started about 15 minutes late for class, I'll open it up for anybody that wants to talk.